And look, that ongoing shambles of foreign criminals, murderers, rapists, pedophiles, all out on the streets, well, it took another turn for the worse today. More emails revealed by my Sky News colleague Andrew Clennell, and he'll join me in a moment, show that Labor knew it had a problem and tried to sneak around it by getting the detainee who took his case to the High Court, the man who raped a 10-year-old boy, removed to a third country. But when that move failed, the Albanese government never thought to prepare a plan B. First, the minister said it was not anticipated that there would be a problem. Now, that's, of course, false. She then said that she'd been advised that they would win the case.
You knew this could happen in June, though, didn't you, or did you?
We knew that there was a High Court action on foot. We knew that it was 20 years of legal precedent, and we were advised that it was likely that the Commonwealth would win the case, that is, allow us to do what we wanted to do, which is keep these people in detention.
That was November 19. We now know from her statement yesterday, after Clennell produced those secret emails, well, that's also false, because once presented with the Clennell emails, she backtracked. And now she's saying, there on the 19th of November, she wasn't referring to the legal chances of winning the High Court case. What was she referring to? God only knows. Then Claire O'Neill tried to tell us that legislation was impossible.
The idea that it is open to the Australian government to simply legislate away a High Court decision is not how our Constitution works.
Then she was, of course, overruled and told the Parliament, in fact, that legislation was necessary. Then she said that Labor's legislation was the toughest ever.
The person the Leader of the Opposition loves to present himself as a tough guy on the borders. He never wrote laws as tough as this, Speaker. He never wrote laws as tough as this.
And it wasn't tough. It only lasted a couple of hours before she had to beg Peter Dutton for amendments on mandatory reporting and ankle bracelets. Now, even after all of this, it turned out last week that at least 4 sex offenders had been released by the government into the community without those ankle bracelets.
No, we don't have the authority to monitor people who are lawfully in our community. There's only 4 reportable offenders that we are responsible for to monitor under very stringent conditions, and if they breach their reporting obligations, then we can charge them with an offence and hopefully get them locked back up.
Right.
That's our plan. Right. For those.
They're not, these 4 that you're talking about, they're not under GPS trackers right now.
They're not under GPS trackers.
And today we learn that one of the foreign criminals, one who was supposed to have an ankle bracelet fitted, well, they said, I don't want to wear it. Effectively told the police to get stuffed. And guess what? Well, he's absconded. He's gone to ground. He's at large somewhere, but no one knows where that is. Even though we know he's guilty of having sex with an underage person and was considered enough of a risk for the minister to think that a security bracelet was in fact needed. Now, what staggers me is that the government can pass a law to say that someone must wear an ankle bracelet because they're a security risk, but when they are approached by the police and they simply refuse, it would appear there's no further consequences. This is Keystone Cop stuff, but it gets worse. Last night, after the High Court announced it would release its reasons for the detainee decision today, but before anyone had seen those reasons, the government brought more legislation into the Parliament, legislation which the opposition, quite rightly, wouldn't support. First, it said we can't support it because it doesn't provide for preventative detention, which Peter Dutton said in the Parliament last night was the only way to solve this mess. And secondly, because the legislation would have to be revised anyway in light of the High Court's reasons published today. So don't rush it again, said the opposition. For God's sake, just get it right.
There should be a preventative detention regime as part of this bill, and it should be drafted with haste by the government. And obviously, once the outcome is provided tomorrow from the High Court, it can be, Deputy Speaker, in accord with the advice from the High Court. We said this to the government early this morning. Don't rush this bill. There's no need to suspend standing orders because you haven't properly drafted this bill. There are flaws all through it, and it has no mention of preventative detention whatsoever. And so the ministers who made the grave errors of judgment and embarrassed the Prime Minister in his absence in the last sitting week have been let loose again.
Well, lo and behold, when the High Court released the reasons for that detainee judgment this afternoon, Peter Dutton was right. As the High Court makes clear, the preventative detention regime is about the only way possible to get foreign criminals off the street if there's still concerns about community safety. Today in Parliament, the government then tried to portray Peter Dutton as weak on border protection, having demonised him for years as being too tough and too heartless. Now, what a colossal own goal from a minister and a government who've got no idea how to keep Australians safe. If the minister had any awareness, she'd just resign, but politically, I'd say keep her there. Keep her there as a potent reminder that on border protection, Labor's got no idea and absolutely no ticker.